Okay, so today we will talk about estate planning. And the first thing that we're going to talk about is the will. So lots of people die and they don't have wills. So when you die and you do not have a will, then you are said to be intestate. The determination of what happens to the remaining property in your what would be your estate if you had a will falls under the Wills and Succession Act, and that determination is now made by the government of Alberta, basically. So it is under Part 3 of Distribution of Intestate Estates, and if you want to look that up, then that's the italics there to get to the actual law. Okay. Basically goes to the kids. If it doesn't go to the kids, it goes to the parents. If it doesn't go to the kids, it goes to the parents, it goes to a sibling, and it just basically breaks down your familial relationship hierarchically, right? And the bank normally has, I think they call it right of first conversion, even before the Canada Revenue Agency. So if the person dies and they have a mortgage or they have a loan or they have credit cards or anything like that, the banker is the first in line, even before, yeah.
Oh, wow.
So even before the kids, even before anybody else, the bank is the one, right? So if they die, if the person dies and they have lots and lots of debt and they have more debt than what they have assets in the estate, then basically, like, if there's anything saleable, it becomes kind of the oldest child's responsibility to sell everything and put it in to the bank account, and then if there's any debt left over, it just gets written off because debts are not inherited in Alberta. No, like if you've got a parent or even a child that dies with a lot of debt and no assets, you're not responsible.
But there's no one gets to inherit it because
the bank is in first. Yeah,
that's right.
Yeah.
So even if you do their last income tax and they owe the government money, the bank gets their share first.
Don't die without a will.
Well, not unless you want to cause a lot of trouble. But you can still cause a lot of trouble even with a will if the will isn't done properly. Okay.
Exactly.
So why do I need a will if we have the Will and Succession Act? Well, if there is no will, then no personal representative is appointed, and nobody speaks for you after you die. There's no written record of what you want. And for survivors under the age of 18, anything that would go to them may wind up in the ownership of the public trustee and held until they're 18 years old. Okay? And there is just a lot of confusion and anxiety for the ones that are left behind because they're not sure of how you wanted things done. And there's a lot of different types of wills, but we're not going to talk about all of them because that would be silly. So there's a holograph will, which is the handwritten and signed without a witness. So if you're on the battlefield and you get shot and you know you're going to die and you write out your will and sign it, it's legal. If you're in an accident, in a car accident, and you have time to scribble out what you want done, it's legal. Foreign will is made in a foreign jurisdiction, but is recognized by the province if it complies with the laws of the place where the person lived. So if somebody from Germany dies in Alberta, the Alberta government will validate the will if it is done according to the law in Germany. Okay? And then there's an international will, so like because she's got her 30-foot yacht that's in dry dock down in Mexico, if she dies and she's got estate stuff in Mexico, then she needs an international will to cover that, and it has to include stuff that is legal in Mexico.
So would that include like a snowbird then that has property down in
Yes.
the States?
Yeah.
Oh.
So yeah, if you have
Oh, yeah,
a summer
she's got
home.
a bank account too. Oh.
Yeah, so if you have a house, like lots of people, when was that? Just after 2008, a lot of people bought houses down in Arizona and in
Yeah, when they
Nevada
developed
and
it, yeah.
Utah and stuff like that. So yeah, you need to talk to a lawyer that does that kind of thing. Like they
Okay.
have to know what the laws are in that state and all that other kind of stuff.
Right, because if you have a holographic will, and it's in Alberta, legal in Alberta, it's not legal everywhere. You know?
That I don't know. See, that's why you got to talk to somebody who's.
Well, I only know that because my dad died.
Oh, okay.
And he had a holographic, like he had
Yeah.
handwritten. And so I had to search to make sure that his was legal.
And he had
Because he
international
lived-
property.
He lived in Saskatchewan.
Oh, okay.
So I had to make sure it was a legal will in Saskatchewan because I knew it was legal in Alberta. So I had to do that.
Yeah, so that would have been part of probate. And that would have been probate in like more than one province, right?
Well, and we only had to probate in Saskatchewan.
Okay, you already had
He
probate.
had nothing, but
Yeah,
we
okay.
had to probate in Saskatchewan.
Because that's where he's from.
Because he had Sun Life insurance.
Oh, okay.
So it was forced. But
Yeah.
other than that, you know, some provinces don't have holographic will, so you have to check
Yeah.
to make sure you have that.
So we'll talk a little bit more about probate in a slide or two. Because it can be a real problem.
You could.
Now there's a joint will too, so if you and your hubby decide that you just want one will that contains both of your wishes, then you can do that. Just have to make sure that when you do that, you have some kind of provisions in there for what happens when one of you passes on, you know. But you can have one will with both of your wishes in it. Or you can have mirror and mutual wills, which is you have a will and he has a will, and you're both beneficiaries of each other's wills, but each will can say something slightly a little bit, well, pretty much they're the same, but might have minor differences. I don't know, like whatever. As many different things as you can think about, you can probably do, right? And then there's the stationary will, which is the will kit wills, and from what I understand, probate lawyers make a lot of money off of these because there's lots of mistakes in them.
Oh, great.
Okay, so basically from the research that I did, spend a dime on an estate lawyer to save $10 down the road. So now we're talking about probate. So why do we even have probate? Well, because we need to validate the wishes,
That's
right?
You have to make sure the will is valid.
Yeah. We have to make sure that the executor is valid, and we have to make sure that nothing in the will is illegal. I couldn't really think of anything in the will being illegal except for maybe somebody, you know, like betrothing their criminal empire to their son or something like that. But I don't know. That was kind of a joke that I was making. But they also have to make sure that it's the very most up to date will, because there could be more than one. There has to be verification that there's no claims to contest the validity. So mental capacity is a big one, right? So one of the things that might happen is, okay, there's a will that was done in 1985, and then all of a sudden in 2012, a new will was made, and it betrothed everything to 3 people rather than the 10 that were in the original will, right? Now we're going to look to see if that person was under duress, like did they really want to do that? Were they forced to do this? All that other kind of stuff. So there could be an investigation into that to make sure if there's a wonky change, they're going to make sure that the person was, you know, contractable when they signed that will.
In my dad's case, he wrote a will, and he mailed it to me, but it never got to me. And so he was in the hospital, and he says, do you have my will? And I went, I don't have a will. And he said, well, then what happened to the will? And I said, I don't know, I never received one. And he said, well, I mailed it to you. And I said, I didn't receive one. So anyway, he got out of the hospital, and he went home and wrote another will. And so then he went back into the hospital, and he died.
Mm-hmm.
And so I had the will that he told me about later. The second one he mailed to me with a note that said, "Here's my will," you know. And so I received that one in the mail, and I didn't receive it till right after he died.
Right.
So then, of course, I was the executor. So
Mhm.
then we rush over to his house, and we got it. You know, there's 6 kids, so everybody's fighting. And in his little black bag that he kept all of his stuff was the original he forgot to mail it. So there is
So now
2
there's-
wills 6 months apart.
Were they at least dated?
Neither one of them were dated.
Oh, geez. So how do you figure
And
out
so
which
then
one
you've
is
got
which?
6 kids that are at each other's throat over nothing.
Yeah.
And they're trying to decide, you know, well, which will is valid. He only made one difference in each will.
Yeah.
But even so, having 2 wills
Yeah.
is not a legal situation. So they had to, no date.
No, one revokes the other, but then if they're
But
not
who's
dated,
first?
yeah, which one's first? Yeah.
So then it went through probate, and they decided which one was. They're both the same,
Yeah.
basically. But they had to decide, and that's the only reason I did probate, really, is
Yeah.
to validate which will was right. Which is crazy that happens, but you can imagine that might happen more than once. You know,
Oh, sure.
Yeah.
old people forget.
Well, yeah, and then every family's got a story of problems.
Oh, there's
Oh, yeah.
nightmares as soon as
bitter,
someone dies.
bitter
yeah.
relationship problems
Yeah.
going back, and you know, like even though somebody might not have any chance of having their claim go through, they might want to hold things up in probate just to stick it to the other kids.
Just
you know,
to be, yeah.
yeah, just to be
that person.
yeah. But anyways, also part of the probate investigation is to make sure that there was actually a personal representative that was assigned. Okay. So these are some of the problems that I found on a couple of legal websites that I went on. The executor is named without permission or knowledge, resulting in the person opting out of the responsibility. So, you know, like some people have actually written a will and put in an executor without talking to the person that they named as executor. And the executor's like, I don't want to be the executor. And they have the right to opt out. And then now you have to have the court figure out who's going to be the executor.
And you can have more than one, can't you?
I think that you can have a clause in there. The way that my family did it is I have one brother, and they made us both executors,
Okay.
so that if one of us dies before the other, then
Okay.
there's still an executor, right? If we both kick it before mom does, I don't know, somebody else will have to do it. But that's, yeah, you can have more than one in
You
case.
can have 6 all listed, because I've done tax returns for lots of final tax returns.
Yeah.
And you'll get a will with 6, and you have to have all 6 of them sign that final tax
Oh,
return.
wow.
Because there's 6.
Yeah.
And then sometimes there's one with a second, you know, if that person can't do it or dies first, then
Okay.
the next person does it. Like,
Okay.
you can have as many executors as you
So I
want,
can do all 3 girls
Which-
as executors.
which
then
is
it's not-
sometimes a mess.
Yeah.
It's sometimes it's a mess, but sometimes it actually saves there being problems.
Well, because the executor takes 10% out of the estate if they wish, right?
Yes,
Isn't that one of the?
but the other thing too is that there isn't a possible question of the validity of the executor if all 3 girls
Yeah.
are named,
Okay.
right?
Yeah, because there's no one that's above the others.
Yeah.
So it's kind of everybody's even,
Yeah.
Yeah.
and you have to discuss, which is sometimes a nice thing too.
So
But it
yeah,
could also be an issue too. Pros and cons.
hopefully though it saves them some money because they discuss it outside of court rather than in court, right? Because like probate fees you'll see aren't very much money when you're just paying the province, no, but when you have to get a probate lawyer involved, like how many hundreds of dollars an hour are you going to pay them for
Okay.
going through everything, right?
Yes.
So they could, like we talked about it before, like if all of a sudden, you know, like if Dad's second will was way different,
Right.
like really
Cut
different,
something
where
right
where
out.
it
Yeah.
really looked like he was coerced into signing something because either he had lost his capacity to be contractable, or because you were, I don't know, holding a gun to his head and said, sign this, you know, like So big changes from the last will to this will can be investigated to check the validity. Multiple wills. Unless you have a non-revocable clause, because we'll talk about multiple wills later where you have wills, one is superior and one is more specific. So you have like an overarching will and one that just deals with specific assets. Then you can have improper preparation and handling of the probate document. So if your executor, say, just is really super frugal, almost to a fault, and won't hire a lawyer and wants to just do this on his or her own,
Yeah.
and keeps buggering it up, then probate is going to take a long time until all the documents are handled properly, right? Mortgaged properties can have a due on sale clause, and as you know, as soon as you die, the government figures that right before you die, you dispose of all of your assets, which means you sell them. So that triggers the due on sale clause. So now, if you die and your house is still mortgaged, your executor might have to remortgage the house,
Oh.
or you might have to just let the bank foreclose on it, or you just sell it. Hopefully the bank works with you a little bit, you sell it,
Okay.
you give them back what they owe, or what they're owed,
Yeah.
and then you split up the rest, right? But depending on whether, like most mortgages have a due on sale clause, so when a death occurs, that triggers a sale as far as they're concerned, and they want the money. Or they want the house. They'd probably rather have the money. Portions,
Or
pardon
you
me?
could maybe try to have a mortgage that has the insurance on it. That
Yeah,
if you die, it's paid.
Yeah.
You know, if it's a joint or something,
Okay.
you know, spouses both own it.
well, if it's a joint, it just gets rolled over
It's just
on the
rolled
rollover rules, right?
Right,
Because the rollover rules are in the Wills and Succession Act as well.
right.
It's like kind of very similar to what they are in the tax law. But if you and your husband were in a terrible accident and the kids had to deal with the house and the house had a mortgage on it and there was a due on sale clause, then probably what would have to happen is the executor would put the thing up for sale and work with the bank,
Yeah.
right? Put the thing up for sale, give the bank what they're owed and the rest of the principal and the interest,
Yeah.
and carry on, type thing. Okay. So sometimes portions of the estate are left out of the will. Like you said, old people are old. Like they don't remember everything.
Yeah.
Maybe they left out the 1949 Chevy or Dodge that's still on the property and it's actually worth something. But they didn't remember to betroth it to anybody. Well, now you got to figure out who gets that. And then there's unclear language, especially in a holograph will, right? But I have heard horror stories of some wills being prepared by some professionals where they really enjoy the lexicon of like a higher level of language, and it's like don't do that.
Where you don't know what you're reading.
Plain language.
Yeah, plain language. Like call blue. Don't call it turquoise. Like it's blue, right? Like just use simple language to make sure that everybody knows what you want to have happen and who gets what. And then delays in processing can cause problems because you could have liabilities that the state has to look after, but kind of like a lot of other things. I mean, like when probate happens, everything gets frozen, right? So, if Grandpa had billions and he's got people looking after his estate, they're not getting paid until probate's figured out, type thing. So probate fees themselves, they're not expensive. For under $10,000 worth of stuff, you're only looking at $35. This gets paid to the court, not to the lawyer. Over 10,000 but under 25 is $135, and it maxes out at $525 over $250,000 in stuff, which really, if you think about it, isn't that much, because a house and a car is going to be more than that.
Yeah.
Right? So now this is the thing, is how do we ensure that there's going to be a smooth probate, right? So probably the first one is make sure the executor or the executrix knows that he or she is named, for one thing. And maybe have them look into, like as you get closer to where you figure your final day is going to be, have them look into what an executor or executrix is supposed to do. So have them read a book. Ensure the executor or the executrix understands the probate process. What are they going to have to do? There's a lot of forms, lots of them. Depending on what's left over and what has to be done and what's said in a will, there could be a lot of different forms that have to be put in. So it's not a bad idea to discuss it with your kids. Like if you, God forbid, you should get diagnosed with cancer or something like that, it's terminal. Time to have the conversation with the three girls. Look at, this is what's going to happen. This is what's in the will. This is what you're going to have to do. Right? For real estate, you can actually put your kids on as a joint tenant. Now, again, if it's mortgaged, you have to have the bank agree to that. And there is a big difference between joint ownership and joint tenancy. Joint tenancy has rights of survivorship. Joint ownership does not. So, on the mortgage or on the deed, it has to say that Sally or Jimmy or Bobby or Susie is a joint tenant. It has to say that on the mortgage if there is one. It has to say that on the deed with the Land Titles Office. That will make sure, for real property, for real estate, that there's no issue as to who it goes to. And then it's kind of like like the old word for it used to be tontine. If you had 4 people that were involved in the purchase of a property or something like that, and you had all 4 people on as joint tenants, then you're looking at a last man standing, takes it all thing, because everybody has equal rights of survivorship. The only thing is, though, is that on your principal residence, it's okay, because your principal residence you don't have capital gains on. But if it's rental property or if it's vacation property, again, as soon as somebody else gets their name put on the deed, now that's a sale. Whether cash or money actually changed hands or not. Because basically what you did is you sold half of your interest to the property to your 3 daughters.
And if they happen to own a principal residence already, now they got 2.
Well, yeah, exactly. So yeah, that could trigger some problems. So yeah, like if they already own a principal property, now they've basically got interest in a property that. But really, though, it isn't. I mean, like, it's a property and it's a gift. So if they're not making any money on it, if they're not making any income on it, they can own it.
They can own it. They just can't sell it.
Yeah, exactly.
And
but she would be really upset if they did anyways, because then she'd be out of a house, right? So, I mean, like, once you've passed on and they've got joint tenancy, and now your final share is passed on to them, they can do whatever they want. And if there's an increase in the value and they get more and they sell it, then yeah, they're going to have to pay taxes on that. But your estate shouldn't have to pay taxes on it.
Okay.
I remember when my dad passed, I had to actually go to the bank, and they had to look it up, because we did have a joint bank account, him and I and my other sister. And so they had said, you make sure that you have that, and they called it JTWR, and that meant joint tenant with rights of ownership.
Yeah.
And so then they told me then that that's what you do, when there's a time for yourself to worry about, you think you're going to die, have that JTWR added to your account. And I mean, I've never done that, but they said that's
You're not nearly old enough yet, or sick
Well,
enough yet.
just put my back out. So
That's not a terminal diagnosis, though. Not that I can remember,
My
anyway.
head on the way down, and there's been.
It's a serious nuisance, but
But you know that, and I never really thought about that. But now when I look at
Hello?
Hi, for Lucy's pickup.
Mm,
This is
nope.
not news or hat.
Nope.
No, oh, that's the wrong one.
Down the
A
aisle a little bit.
further? Okay,
Yeah.
thanks, guys.
No problem.
But now, you know, I see slips sometimes, and I see that JTW, you know, so other people have done that. They've
Yeah.
made sure that they've
Yeah.
got that joint tenant.
But again, it's all about, it's the tenant though, right? Because you can have joint ownership,
Yeah,
but that doesn't have survivorship rights.
that's right.
So you have to have the joint tenancy.
You have to have the
And-
joint tenants.
And anytime, if you've got a mortgage on your house, anytime that you're gonna change anything on a title, and like a mortgage is a lien, basically.
Yeah.
If there's a lien on the property, then you've gotta, you basically have to remortgage it. Like, you have to pay out the old mortgage, and you have to have a new mortgage where all four of you are now
Okay.
mortgagees.
Okay.
But
Okay?
how many people know about that tenancy?
Yeah.
You know, that just shows. Very
At
few
least,
people
at least 3 of
understand.
us know, but
Yeah.
I don't, I don't know how many
People
more.
understand that.
So then, like, if anything happens to me, we have a joint mortgage with myself and my husband.
Yeah.
So then the mortgage would just revert to my husband
It's a
if I
rollover
passed.
thing, yes.
So it would roll over, but if both of us passed at the same time, like you said,
Yeah.
then if the girls aren't on as a tenancy, then it just automatically would do that close of bill sale thing
Yes.
with the bank, and then they would have to
Yes.
sell the house and work with the bank to just
Yes,
do that. Okay, unless
because- because-
one of them could apply for the mortgage and keep the house.
yeah, but at the time when you're passed on though, it becomes a lot stickier,
Okay,
right? Unless it's actually in your will, but even then, like, you wanna have all this stuff done prior, because what if the bank says, no, we're not doing it?
okay.
Like, they have the right at that point to say, no, we're not doing it. Okay, so like,
So
and
bank
some
gets
lawyers,
first claim though, right? Like, because if there would be a mortgage outstanding,
well, if,
then,
it, like, the way that I understand it, okay, so there's 5 of you,
Yeah.
okay? And all 5 of you are joint tenants. Now, if one of you dies, the other 4, you're a circle of equals
okay,
on ownership of that thing, right? So now one isn't a leader.
okay,
One doesn't have any say. I mean, like,
Okay.
Dad does because he's Dad, but
yeah,
legally, no.
okay,
Okay, so one of the things that some lawyers might ask you, if they're good lawyers, they probably will, is to say, how do you know for sure that your kids aren't going to sell this thing out from under you? Well, I think it would be a little harder than that, because again, there's a title change, so I don't think they could just stick a sign up on the lawn and one of them could sell it out from underneath everybody else. I don't think that's going to fly, because if you do something like that, I think you have like 90 days to contest the sale or something like that, and you can go back into the courts and say, no, I didn't want that sold, I need that stuff back, right? So then the other ones could do something like that. Like, it would be a big pain in the butt, right? Because if somebody tried that, and it did actually change hands, and there was a money transaction, and now you've got to go to court and get that all backed up, it can cause problems. But so long as you don't have a real, like, con woman in your family or
Yeah.
con man in your family, I don't think it's a big deal.
Maybe it's not even that. Like, and I don't understand this myself, but if you had five people all equal, what if somebody had a lot of debt?
Well, that's
Would
going to
they-
be a
They're
problem.
have a claim.
No, that's going to be a problem with the bank, because if somebody is a bankrupt, right?
Yeah.
Obviously, they can't have their name on the mortgage.
Yeah.
Not until bankruptcy is discharged and a few years after that, right?
Right, but they can't take it off either in their bankruptcy, can they? Or will that be looking like? they're
Well,
trying
no,
to
they might
get
have
rid
to.
of their
They might be
assets?
I was
forced
gonna
to.
say, yeah, if you're claiming bankruptcy, you can't have assets.
Well, no, they might be forced to liquidate their share
Right,
of their equity, right? I mean, like, if it's, yeah, it could get really
it
messy.
could hurt the others. Is
Yes.
My point, it could hurt the others.
Yes.
If you have someone that's not keeping up and they fall behind and all of a sudden somebody shows up and they own
Yeah, and hopefully
They
the
only-
other ones would maybe be able to buy the share out,
Right.
right? Because then you could remortgage again. Now the only thing is like, I don't know, like there's certain rules in the Bankruptcy Act that say that you're not supposed to dispose of anything within like 60 days of actually claiming bankruptcy. So like if somebody looked like they were headed for a slippery slope, maybe the other four would have to come together and say, look, we don't like what you're doing here. You've got a stake in the house. We're going to buy you out, and then you go do whatever you want. But you're not going to be a problem for us through this. So that's something. Yeah, everybody's got to get along.
You'd have to
Yeah.
communicate if you were gonna go do your bankruptcy and not tell anybody.
It wouldn't be a good idea to do it if your kids were sprinkled amongst all of the United States and most of the provinces, right?
Okay,
You'd have to have communication. You'd have to be able to at least have a Zoom meeting every once in a while.
So we could do one of two things then. We could either put the girls on for joint tenancy, which we would have to do either with the mortgage with the bank or with the deed, right? Or we could just leave it that if both my husband and I pass on at the same time, then we could just have it in the will as that they would, dispose of the house if there was still an outstanding debt, and then to split it between the three of them.
Yeah, I think that they would have to do
Okay,
that.
okay.
Hopefully it's paid off way before that ever happens.
Well, we haven't done a bike trip for a really long time, and that's the only risky thing that we really do, so.
No, exactly. You're not racing NASCAR, so you're probably okay.
No, I don't have any intentions of jumping out of a plane, so
No,
I won't do anything risky.
the thing that we're going to talk about a little bit next is actually using a trust as a substitute for a will to avoid probate.
Yeah,
There are no tax advantages to having a trust. In fact, it's probably going to cost you more money to have a trust than it is to go ahead and form a will. But if for some reason your estate is going to be really complicated and you've got a lot of beneficiaries and you want to make sure that there's no problem in probate, the best way to avoid probate is to not have a will, do a trust. Okay? But it's not cheap.